today for the NEPA webinar. We have two great partners from one of the leading firms in our country and that has provided tremendous advice and counsel for many of our member companies and companies that are in the broadband industry deploying networks. And they're here with us today, Fred Wagner, partner, and Craig Gilley, also partner at Venable, on the challenges that our broadband companies face as they deploy fiber and wireless networks around the country, as they face the permitting realities that many times slows the deployment of networks, increases the cost. And so I think their advice and counsel, and as they outline the best strategies and practices as you go through and overcome those hurdles and barriers to deploying networks, will be very useful and helpful to everyone who's connected into the webinar today. Let me quickly introduce both Fred and Craig. Fred focuses on the environmental and natural resource issues associated with major infrastructure, mining, and energy project development. He manages and defends the reviews that are performed under the National Environmental Policy Act, or NEPA, or the equivalent state statutes. Craig provides a broad range of services for regulated communication entities, as well as information technology, education technology, and private equity companies. Craig's primary practice involves counseling providers that are doing both cable, internet service, broadband, video programmers, satellite providers, and wireless wireline telecommunications providers on a very broad range of both legal, regulatory, operational, and transactional issues. We thank y'all for taking time to be with us today, and I look forward to the presentation and the discussion. You can submit questions to both Fred and Craig as they go through their presentation. We welcome that interaction, and I'm looking forward to the discussion today. Thank you. Fred, Craig.
Hey, Craig, you gonna kick it off real quick?
I am. Chip, thank you. First, let me introduce Venable. Venable is a national law firm based here in Washington, D.C. We have about 750 lawyers practicing in all major areas of corporate and regulatory and litigation and other legal areas. I am a telecommunications and communications law partner here at Venable. Fred is in the environmental group, but really he's an infrastructure deployment lawyer that assists companies getting major infrastructure projects through the federal regulatory process. Part of our practice that we're part of here in DC is a large multi-agency practice. We hit all major areas of agency law that impact companies, especially in the technology space. And part of the advantage of having large presence here in Washington, we have over 275 lawyers practicing in front of all these different agencies and before Congress and in other areas of the administration, is that we can provide different contextual advice involving our clients' problems that involve multiple agencies. And that is what we're going to talk about here today. So my practice is telecommunications. Fred practice is land use and infrastructure deployment, how they're impacted by the environmental and historic preservation laws. So our purpose here today is to educate you. We're not here to, these are complex topics that we're going to talk about today. We know that they are impacting your business, that in ordinary times, they're an impediment to getting business done. We know in the current environment where a lot of the member companies have taken federal monies and grants to get broadband project for their broadband projects, broadband deployment, they're under pressure under those grants to get things done in a timely manner. That the pressure is exacerbated when there are permitting issues that are in the way. It's just not ordinary business. It's actually government imposing a requirement on you, and then at the same time telling you you can't do something without a certain permit. So again, we're here to educate you. We're not here to confuse you or to frustrate you with how complex these laws are. We want to provide a vocabulary for you and some context for you and give you some historical background as to where these laws come from and how they interact with your business, so that you can help navigate your business with help of professionals like us, obviously, through to the other side where you get successful completion of the project. So I will turn it over to Fred. This is really his bailiwick, and he can introduce his practice more in detail and then parlay right into starting to describe how these laws work and how they impact your business and how we can navigate through them. So, Fred?
Thanks a lot, Craig. I think Craig did a great job introducing me and my practice, so let's dive right in. Hey, look, this is an amazingly timely topic. Right now on Capitol Hill, there are any number of proposals. There's a big hearing tomorrow in the Environmental Public Works Committee at the Senate on this very topic, on permitting and streamlining NEPA reviews and getting all the infrastructure that's been funded through the bipartisan infrastructure law, through the Inflation Reduction Act, through other acts, getting it into the ground and getting these projects moving. And all too often there are impediments to get it moving, and the communications world has been, no different. What I'm going to do is be giving you a high-level overview of the major laws that affect the permitting of your projects, but then also diving in a little bit to tell you some of the things you can do and some of the practical advice to help move things along more quickly. So I'm looking forward to the discussion. So first we'll start with NEPA, then we'll go to the Historic Preservation Act. What is NEPA? NEPA has been called the godfather of all environmental statutes. It was passed in 1969 and signed by President Richard Nixon. A little trivia there, the father of the environmental movement, Richard Nixon. And it's a remarkably short statute. Compared to some of the statutes that you all involved in day in and day out, others in the environmental sphere that are hundreds of pages long, NEPA is 6 pages long. It's 6 pages long, that's it. And it has just 2 functions, 2 and only 2. It wants to make federal agencies, allow federal agencies to make informed decisions, and those decisions should be benefited by robust public participation. That's it. Those are the only 2 goals of this statute that has been, litigated now for over 50 years, and a whole robust, bookshelves full of common law about NEPA. But that's really the only 2 purposes of the statute, to make informed decision making. But as the last bullet point says, and this is the most important thing for you to understand, it does not dictate particular outcomes. I like to joke that, a federal agency can propose to drop a neutron bomb over Manhattan, and as long as they look at the effects of it under NEPA, they can do it. You're not prohibited from taking actions that otherwise may be controversial or difficult. NEPA just says, think about it. Look before you leap, understand what you're going to do, and involve the public in the decision-making process. And NEPA review is triggered very simply by dollars, if there's federal dollars involved in a project, or if there's federal approvals or permitting. And you'll see I gave some examples here in the second bullet point on the screen. If there's FCC licensing, if there's access agreements for fiber, laying fiber, or co-locating fiber in highway right-of-way. I was the general counsel of the Federal Highway Administration for Barack Obama in his administration. And one of our main initiatives was trying to promote laying of broadband along the highway right-of-way. Well, that partnership, that work with the Federal Highway Administration would be a trigger for NEPA review. So very clearly, even though it's completely private action, if there's some federal approval necessary, even without any federal dollars, NEPA is triggered. The converse, of course, if that is completely private, no federal relationship at all, then NEPA is not required. States, there's many states that have their own NEPA type statutes. We call them mini NEPAs. In some states, it's anything but mini. From those of you from California, you're well aware of CEQA, and that's a very robust statute with a whole bunch of litigation in its own right. But we'll be concentrating today on the federal law, not so much the state laws. So how do people comply with NEPA? One of 3 ways. There's only 3 ways: categorical exclusions, environmental assessments, and environmental impact statements. We'll talk about each. The surprising thing to know, and a lot of people are unaware of this, because when you read about NEPA in the newspaper, you'll read about the very complex, lengthy analyses that take years and years and years. And those are usually the environmental impact statements, the big, long documents. Environmental assessments are one level below that. They're designed to be more streamlined, more brief analyses about a project's impacts. But over 92% in any given year, sometimes it's high as 93, 94% of all federal actions are assessed under NEPA using categorical exclusions. So when you hear about all the controversy over NEPA and how much time it takes, the surprising information is that most of the work under NEPA is done under categorical exclusions. So let me tell you about those. Categorical exclusions are not exemptions from NEPA. It's still NEPA compliance. What they are is an application of a list of typical actions that every agency maintains, including the FCC, of typical actions that do not usually have significant impacts on the human environment. If your proposed action falls under that category, you can apply a categorical exclusion to that list, and oftentimes it's done simply through a checklist. Nothing more than that. Internal paperwork, no public participation. It could take a matter of weeks, a month, and then that's it. That's how categorical exclusions apply. So when you hear about NEPA reform, oftentimes you'll hear congressmen and senators say, oh, we need to add more categorical exclusions, because they like that. They like the idea that actions can fit under these broad categories where ordinarily there are not a lot of impacts, and so you can get through the process very, very quickly. And there are literally hundreds of categorical exclusions across the federal government. Now, even if you fall under a category of one of the actions is under a categorical exclusion, there's an exception. Generally, it's called extraordinary circumstances. If there are extraordinary circumstances, you're siting a facility right next to a nest of an endangered species, or you're immediately adjacent to tribal land, for example, maybe using a CE is not the best thing to do. So there are exceptions to when you may otherwise be eligible for a CE, but it might not be the best thing to do. Again, those are the vast minority of cases, but I need to let you know there's an exception to that. And if you can't use a categorical exclusion, if you're not eligible for a categorical exclusion, this is what you do: an environmental assessment. When the Council on Environmental Quality, this is the White House agency that writes the NEPA regulations, first came up with the concept of an environmental assessment, it was supposed to be a brief analysis of impacts. Brief. In practice, many environmental assessments get very, very long, but at least in theory, they're designed to be more brief. And almost always, an environmental assessment ends up in what's called a finding of no significant impact. My favorite acronym in the entire federal family of acronyms, a FONSI. I love that acronym. Hey, FONSI. But that's the end of the EA process. And it means we've looked at the impacts. There are no significant impacts associated with this finding. And then the final action is this FONSI. In some instances, when you do an environmental assessment, there could be some resources that may involve potentially significant effects, but you can then impose mitigation measures to reduce those impacts to insignificant levels. And that's called a mitigated FONSI. We think there could be significant effects to fill in the blank, but if we do such and such a things, if we implement this plan, we can get below the threshold of significance and we can declare a FONSI, a finding of no significant impact. The timing to do EAs varies substantially. Well, why is that? If they're supposed to be brief, if they're supposed to be relatively simple. Well, let me give you an example. I worked on the Obama Presidential Center in Chicago. There was an environmental assessment done on that, but it was in the middle of the city. If you've done any work, I'm sure your members have done work in major urban areas. There's lots of sharp elbows. Everybody is politically connected. That EA took 2.5 to 3 years to prepare. And it ended up being relatively long with a whole bunch of appendices. It was just a little bit more complicated. So not all EAs are brief, but that's the intent behind an environmental assessment. You'll hear in a minute, this is where all the action is, for the most part, in the communications world. The last category, environmental impact statements. These are the ones that you hear about in the news. When President Trump took office, he came to my old agency, the Department of Transportation, and he literally took an environmental impact statement for a major highway that I worked on in Maryland. He was handed the loose leaf, like it was like this. He took it and he literally threw it off the stage. It was, I'm not making this up. He took the loose leaf and he chucked it off the stage and it landed in a crash on the floor. And he announced to everybody in the auditorium, he said, forget about this. We don't want to do these huge documents. We're going to do it much faster, much cleaner. So that was one of the first things he did actually when he was president. And that was because these EISs are huge. They sometimes take years to produce. The average length of time to do an EIS in the federal government is 4.5 years under the latest statistics. And they're triggered by major federal actions that result in significant impacts to the human environment. That's the key phrase. So if you're doing a project and you just can't avoid impacts to air, water, critters, you name it, you're going to be doing an environmental impact statement. And this is where all the complexity, this is where the controversy exists. But it is also the most rare circumstance. Maybe 3 to 4% in any given year of all major federal actions involve the preparation of an environmental impact statement for context. Another 4 to 6% EAs, now maybe closer to 8%. And then around, again, 90% are categorical exclusions. So how does this apply to your industry? Well, the FCC, like every agency, is mandated to have its own NEPA regulations. And there they are, CFR 1.1301. And for the most part, what you'll read, and if you go to the FCC website, which I encourage you to do, you will see that tower siting and dealing with towers dominates the FCC's thinking in this space. How do we get these towers done expeditiously? How do we get co-locations done expeditiously? How do we get sites that need to be repaired or enhanced done expeditiously? And this is the authority that they use, their own NEPA regulations at 47 CFR. But they also, just like every federal agency across the federal government, they refer to the Council on Environmental Quality, CEQ, the regulations at 40 CFR 1500. I mention this because during the Trump administration, they amended tremendously the NEPA regulations from the CEQ. The Biden administration announced almost on day one that they were going to change them. They've had one phase of amendments to the CEQ regs, and literally any day now, we're expecting the biggest tranche, the phase 2 amendments to the CEQ regulations. So this is very much a watch this space kind of moment where there could be additional changes, additional procedural ways to streamline NEPA review built into the new regulations. So, this is something to be aware of. And I know our firm, Craig, will be doing a big client alert when the new regulations come out. So if people want to get a synopsis of what the regulations are going to look like, that's one way they can find out. I raised both these two bullets because the role of the lead federal agency is the most important thing for you to know. So for example, you're doing a broadband project and you need access across US Forest Service land. The likely lead federal agency is the Forest Service. And they have their own NEPA rules and their own NEPA regulations and their own procedures, which are similar to, but not exactly the same as the FCC. And so you have to be aware of who's going to take the lead on any given project. The FCC, most of its actions, they try to cover under EAs at the most, and then otherwise categorical exclusions. Very rarely does the FCC get involved in EISs. Very, very rarely. But when you go to the Forest Service or the Bureau of Land Management or any of the other agencies, the Department of the Interior, where you may be impacting federal lands, or even my old agency, the Federal Highway Administration, these are folks that are much more used to doing large-scale, complicated NEPA documents, right? And so you have to understand it's a different world. It's a different group of people that do the NEPA analyses for those agencies, and the rules are going to be slightly different, and may introduce some levels of complication that don't exist if you're going through only the FCC through tower siting, where there are pretty standard ways of going about it under the regulations, and they try to get you done really quick. For your industry, You have to, and like many other industries, actually, the private party, the project applicant is crucial in this process. In most instances, it would be you or the consultant that you hire that prepares the NEPA documents. Why is that? Well, it's just a matter of resources. Each federal agency in no way has the capability or the resources to do the NEPA review for every project that it sees. They just have not enough people, not enough personnel. But that's why they rely on the private parties and their consultants to do this NEPA analysis. However, you do the analysis, the agency decides. You analyze, the agency decides. And that's absolutely imperative to understand, right? Why do they do that? They do that because they don't want to give the perception to the public that when a private party and its consultant submits a NEPA document for review, that the agency is just going to be a rubber stamp. They want to ensure what's called an independent review, independent analysis of these reports submitted by the project applicants. And the rationale makes sense. If we're doing a fair analysis of resource impacts, a fair analysis of project alternatives and project mitigation, we just don't want to take the private party's word for it. We, the agency, need to be sure that we're taking this independent review of the information we receive from third parties. So the process is set up with you or your consultants doing the analysis, the agency reviewing it, maybe asking you questions, asking you to change some things, asking you to sort of supplement some of your analysis or answer questions from the public. And then ultimately, the agency makes the final decision. That's the rhythm of how these projects work.
Fred, let me interrupt you for a question here. I hear you saying that the threshold question is to determine which agency is going to be the lead agency. If I'm a broadband provider, and let's say I'm doing an out west broadband build across country, let's say from Billings, Montana to Bozeman, Montana, likely to cross federal lands, likely to cross different flavors of federal lands, is there going to be one agency that's going to cover my entire project? Or because I have different flavors of federal lands or different areas that I'm impacting, could there be different lead agencies for different segments of each of the project, each part of the project?
The short answer is yes. And depending on the project and the facts at issue, it could be that the majority of the impacts or the majority of the land that's at issue, I'm just making up, is the Forest Service. But there's some piece of it that's the BLM. I've been involved in projects, Craig, where when there's two federal agencies involved that way, one will decide to take the lead and do the majority of the analysis. And then they'll work with the other agency as either a co-lead, but really, one takes, the predominant role. Or if it's a factual scenario where it's like the vast majority is one agency and just touching on the other, then the one agency will be a lead and the other one will be what's called a cooperating agency, where they'll have input for the impacts on their land and the approval that they need. But it's pretty clear that the majority of the approvals have to come from the one agency. All depends on the facts, right? It all depends on what's going on. Under the rules, the other thing I'll say, especially under the rules written by the Trump administration, and I predict that will still be the rules when the Biden administration is finished with them, they really try to combine all the approvals necessary into one document, Craig. And the principle under the Trump administration was called one federal decision, OFD, one federal decision, they called it. But so if there's multiple agencies involved, you still write one NEPA document and both agencies can make the final decision as long as they have provided input into that one document. So the last thing that anybody wants is to write separate EAs, like two EAs, right? That would be crazy. And so under the one federal decision premise, the agencies collaborate, they write one document and decisions are made in reliance on the information prepared from that one document.
But I assume there could be a strategic decision to maybe split the project into separate pieces and apply because of different agencies involved, and maybe one segment is problematic and you don't want it to infect the other, or is that just generally a bad idea? You try to keep it all together.
Generally speaking, you got to bite the bullet, and breaking it up and doing it separately usually is the worst scenario. because it allows it promotes duplication of effort. Remember I told you the two parts of NEPA, wise decisions and public participation. You break it up, it allows two opportunities, two bites at the apple for public participation. If there are problematic parties or advocates that might get in your way or be litigants, well, it gives them two bites at the apple, Craig. So the general rule of thumb is that even if there are different lands you have to cross and different issues, if it's a project, do it under one document and try to get the collaboration and coordination of the different agencies to work together. The good news is that under current law and under policies being promulgated by agencies across the federal government as well as the CEQ, they are not just encouraging but demanding that agencies work together collaboratively to avoid duplication, to avoid doing documents in seriatim, right? They don't want to see that anymore. And one of the things that I predict is when the new CEQ regulations come out any day now, I think some of those principles are going to be baked right in to the CEQ regulations.
So if I'm a broadband provider and I'm under pressure, let's say from a lender, or because I have a government grant, I have a build-out requirement I'm trying to meet, and I'm trying to plan and get some certainty at the beginning, and I can identify what agency is going to be the lead agency. Given the three categories that you provided before, is it fairly obvious to me which of those three categories it's going to involve? I guess I'm looking for certainty so that I can plan and make sure, especially I meet my build-out requirement.
That's right. I mean, look, I think there are triggers that folks in this industry are well aware of that might ordinarily trip an environmental assessment type level to a fully IS. They're well aware of it. And it could be, again, the ones that I've seen that are very sensitive involve tribal resources, cultural resources, involve crossing habitat of endangered species, things like that. Dealing with the sage grouse in the part of the world that you were just talking about, for example, right? That's something that could be problematic and something you can anticipate in advance could be a trigger to a fully IS as opposed to a full EA. But what I'll say is, and one of the things that is a great strategy for folks in the industry, is that for the most part, the types of projects you're dealing with, for the most part, are not building massive mines or highways or transmission lines, right? The nature of the disturbance and the level of disturbance is going to be much more modest. And there are ways to build into your project through commitments to mitigation, through commitments through engineering design, through commitments to minimization and avoidance of impacts, where for the most part you can plan, as you said, because there's money involved and there's timing involved, where you can plan for the environmental assessment level of review as opposed to the EIS. Now, if you're in a situation where you just can't avoid it and you think there's going to be significant effects to some of those sensitive resources I talked about, well then, again, you can build in the front that this may take a little bit more time and let people know that. The hope is, though, for a lot of the projects we're talking about, they can be done under the environmental assessment category, which should be done in a more confined period of time.
And I assume, and then we can move on, that it is best to try and anticipate the problems and get ahead of it, as opposed to waiting for there to be a complication and then try to propose mitigating steps once there's already that complication.
Yeah, I mean, the fallacy of NEPA that people think is that, oh, I'm thinking of an action and I'm going to go out and then I'm going to discover all this stuff. No, it doesn't happen that way. Especially working with private parties, you're planning. You're thinking about where you want to go. You're anticipating a lot of these issues. So by the time you approach the agency, say, hey, it's time to get this approval. It's a time to get this permit. It's time to get this right-of-way access. You're not going to be coming with some blank slate. You're going to be knocking on their door with a sense of, hey, not only is what we want to do, but here are some of the issues that we think we're going to encounter, and here's some ways that we're going to try to deal with it. It's rare where an applicant goes to the agency and there hasn't been any measure of communications or preview to some of these actions. For the most part, when I work with clients, Craig, I do pre-application meetings, pre-application disclosures, so that we can target in onto the things that really matter and not face any surprises once the analysis is starting. Well, one of the things that causes delay is litigation. And so NEPA is a common law statute, as I said earlier, which means that it's only 6 pages long. Remember, the statute's only 6 pages long. The regulations are only about 30 pages long. So a lot of the rules and the law around NEPA has been created through case law, through common law. And there are thousands of NEPA cases over the years across the country. But there's some good news. The good news is that under the Administrative Procedure Act, there's no cause of action under NEPA. Challenges are done under the APA. There's a pretty favorable standard. The decision, in order to be upheld, it just can't be arbitrary and capricious or not otherwise in accordance with law. That's the buzzword. That's what you're trying to avoid. Generally, a favorable standard, on behalf of the government. But it raises the question, when is enough? How do I know that I've looked at this adequately? One, to get the approval of the agency, but then two, to survive any legal challenge. If somebody challenges our EA or somebody challenges their ES, how do I know, when enough is enough? And so what we do with clients is we try to apply what I call a risk assessment model to NEPA compliance. If you're working with somebody and they say, oh, we're worried about a challenge to such and such, and the advice you get is, well, just do more, you're not getting good advice. The real advice should be, okay, what's the risk associated with that resource? What are the level effects that we're talking about? What are the statutes that are at play? What are the advocacy groups that are involved? How much risk are we really talking about? And then you can make an assessment based on that analysis about how much you have to do and the scope of analysis that's appropriate for that particular issue. But most importantly, truly listen to and respond to the public and the stakeholders involved in a NEPA process. Again, remember, not everybody has to agree. As I said right at the outset, NEPA does not command specific results. You don't have to do the best project for the environment. You don't have to avoid every impact even, but you have to make an informed decision. So by definition, not everybody's going to agree. I've never worked on a project where everybody agrees. That's impossible. Not a project with any, weight to it, any sort of, significance. But if you've engaged the public and you've heard them and you've incorporated some of their concerns into your decision, you're going to be okay. And it's going to work out at the end. And honestly, you're going to end up with a better project, which is really the goal for everybody.
Now, when you say the public and you talk about these third parties and interest groups, and where are they coming into the process? How are they participating? And do I really need to respond to everything everybody says?
Well, if you're doing an environmental impact statement, there are mandated comment periods built into an EIS. So the short answer, Craig, is yes. If somebody's submitting meaningful comments on the draft EIS, you have to respond to everyone. And you have to have meetings, and you have to make the documents available to the public. And you're well advised to do outreach, especially to the most directly affected communities. And now with this administration and with current policy initiatives, absolutely to disadvantaged and otherwise overburdened communities, EJ communities, environmental justice communities. So yes, the rules absolutely call for agencies to respond to comments and to have affirmative outreach plans to get the input from those communities. And now even with environmental assessments, we're finding more and more agencies building in comment periods to enhance and promote public engagement and public participation. So again, if NEPA only has 2 goals, better decisions and public engagement, those rules get to be pretty specific about the obligations of agencies to respond to comments. And if the agencies have to do it, that means you have to do it. That means the private applicant has to do it as well. And then, the third point on the slide is, NEPA is a statute that's tested on an administrative record. If a case gets challenged in court, there are no witnesses, there are no depositions, there's no drama. I watched the last episode of Perry Mason last night. Great show. There's no Perry Mason moments. It's just on the papers. It's just documents. So when you get to important decisions, when you're going through your record, document your decisions, document your discussions with the agency, document your conclusions in a way that it's obvious to a court reviewing your record. But by the same token, don't become a victim of paralysis by analysis, right? Just you don't have to overanalyze everything. You have to be clear. You have to show in your record why you made the decisions that you did, and you don't have to go overboard to make sure that your record is documented clearly. I use this example a lot. There's an old legend of famous Rabbi Hillel, who was teaching in the public square, and some wise person decided to harass the rabbi. And he goes up to the rabbi and he says, "Rabbi, if you're so smart, I want you to teach me everything about your Bible while you're standing on one foot." The rabbi hops up on one foot. He turns to the person who is harassing him and says, "My friend, treat your neighbor as you wish to be treated. The rest is commentary." That's the legend of Rabbi Hillel. Well, for NEPA, that's really the same kind of story. Explain to the public the impacts of your project. Tell them how you're going to try to address those impacts. The rest is interpretation. And there are best practices to focus your NEPA review. You don't have to look at the impacts to the endangered species if there are no endangered species near your project. You don't have to do a tremendously lengthy air impacts analysis if there are not going to be air effects related to your project. If there are going to be effects related to cultural resources, though, you should concentrate your efforts on that and do so in a way that's fulsome and comprehensive. Exercise some proportionality, and that's fine. And the other thing to realize at the end of the day is that despite the fact that there have been defeats, and there are certain notable ones out there, if you all have followed some of the stories about the offshore wind project off Cape Cod, Cape Wind, I mean, that project's been litigated for 15 plus years. You've been following litigation over the Standing Rock litigation, over the pipeline, right? The controversial pipeline. That litigation went on forever and there was a big defeat there. Those do get the headlines, but for the most part, the project proponent usually wins. For the most part, the government wins and the party that's trying to build the project wins. So don't go overboard, document your decisions clearly, engage the public in a way that's meaningful, and you should be able to survive challenges to NEPA analyses. Before I go to the next statute, Craig, is there anything else in the Q&A before I hop to historic and cultural resources?
Oh, just one bit of context. So in some regulatory contexts, like grant funding, government is your friend and the staff in a particular agency tends to be more helpful than not. In other contexts where maybe there's an enforcement action of regulation, the government is your adversary, and there's a bunch of different flavors in between. Here, the stance of the government towards your application, I mean, of course, if you submit something that's offensive to the administration in power, it's going to be adversarial. But would you say that generally the lead agency is more your friend or more your foe? And maybe it's just contextual as to what the project is and who's opposing it.
Yeah, I mean, I think it's a little bit, cutesy, but they're your frenemy, for sure. Their mission is to build out the broadband network, for example, right? The administration's priority is to connect rural areas via broadband, to bring people into the 21st century and to make sure that there's access to the internet, et cetera, et cetera. So there are policy initiatives that are consistent with your project that are high priorities for an agency or for the administration. However, that being said, they don't want to be perceived as, whatever the agency wants, right? Whatever you say, you get. So that's why they do take this hard look. That's why they do take this independent review. So they don't want to seem to be too close, Craig. They don't want to seem to be, too much in bed with the industry that they're regulating in this case. So I really do call it like a frenemy situation. They certainly want to support projects. They certainly want to support the mission of expansion of broadband services, but they also want to do so in a way that gives comfort to the community that they are indeed an independent overseer of these projects.
So when I have a project, part of what I need to think about is obviously the stance of the agency and administration that I'm presenting to, and then anticipate who the foes might be and get some intelligence so that I can strategize as to how to present my case to hopefully minimize the difficulty to get it approved.
100%. In most of the projects that I get involved in, you know, let's be candid. I don't get involved in projects where there's no controversy. Right? I get involved in projects where people are expecting there to be some tussle or there's some controversy associated with it. And in those instances, we know full well, you know, what the objections are going to be. We know the communities that are involved. We know if, you know, if it's an environmental group like the Sierra Club or the NRDC, we know if they're going to be involved or something like that, you know. And so what we do is we deliberately understand their key issues, their key concerns, and make sure when we get to those aspects of the record, you know, we're doing a good job on those issues in particular. So absolutely, you know, we try to put it on our thinking caps. We try to act as if we're a plaintiff. What would the plaintiff say? And then we try to build our record around it sometimes when it's pretty clear that we know there's going to be a challenge, or it's pretty clear that there's a history of litigation over a particular area. All right, let's transition to the next topic on for the webinar, the National Historic Preservation Act, the NHPA. And again, like NEPA, the NHPA is a procedural statute. It's a procedural statute. It's not outcome-oriented either. It does not mandate preservation. So what do I mean by that? If there is a federal undertaking, there's a project that requires federal approval, and you have to go through the NHPA process, which we'll talk about in a minute, you can ultimately take the action that damages the historic and cultural resource. It is not a prohibition, but there are steps that you have to take in order to address the potential effects on a historic or cultural resource, right? And like NEPA, its goals are to inform the public, interested parties. There's a term of art under the NHPA, they're called consulting parties, as well as the broader public, about the consequences of your action on historic resources in the area near your project. And the statute encourages discussion of ways to avoid those impacts, to mitigate those impacts in many different ways. Some of you who live in big cities have seen this before. You've seen buildings that seem to have the shell, the outside shell of a building with some of the old stonework and things like that. And out of the shell of the building is, you know, arises this very modern glass structure. So on the bottom floors, you'll see the shell, the stonework and whatnot, and then you'll see this modern structure coming out of it. If you see a building like that, in large part, it's because of the National Historic Preservation Act. That's how it works. You were able to tear down that old building, but there were measures involved to preserve some aspects of it to preserve the historic resources of our country. And in those instances, the shell of the building is preserved so you can see what the building used to look like, even if a brand new one arises out of it. That's a classic example of how the NHPA works. But again, like NEPA, there got to be a trigger. If there's no federal action, there's no trigger. The term of art under the NHPA is called an undertaking. An undertaking. And you'll see what the definition is in there from the regulations. Again, money, direct jurisdiction of an agency or an approval, license, permit. That's what a federal undertaking is. So again, even if it's a completely private action, if you need to get federal approval for it, that's going to be enough to trigger an undertaking under the NHPA and the procedures for the NHPA. But the other thing you need to be aware of is that the NHPA only deals with effects to properties that are listed on or eligible for listing on what's called the National Register of Historic Places. It's a list. It's an actual list of properties, places, things that have historic and cultural significance to the United States of America, and they find their way on this list. My favorite job in the whole federal government, I told you my favorite acronym in the federal government, FONSI. My favorite job in the federal government is called the keeper. That's what he or she is called, the keeper. It sounds like something out of, you know, I don't know, Dungeons and Dragons or, you know, some of the shows like that. The person's called the keeper of the National Register of Historic Places. That's their job. And so there is a list and there is somebody who manages that list, and there are processes by which a property gets to be put on the National Register of Historic Places. What are they? Generally speaking, but not always, you have to be at least 50 years old, and you have to be associated with some sort of historical event. You know, the cliche, George Washington slept here, that could be enough to get you on the National Register of Historic Places. George Washington built a home here, Mount Vernon, that's going to be on the National Register of Historic Places. You know, George Washington signed his farewell speech in this place, that could get you on the National Register of Historic Places. But in addition to that, there has to be some integrity remaining to the property. So if a property did have some historic event happen, but has been rebuilt, it's been, you know, it's now aluminum siding over it, all the original features of the structure are no longer there, it may not be eligible for the National Register of Historic Places. It has to maintain its ability to show its historic integrity and to convey its historical significance. 106 works hand in glove with NEPA. You're never doing NHPA all by itself and not getting involved in a NEPA review. They go hand in hand. And most of the times, hopefully all the time, they are coextensive. So the assessment of impacts to historic and cultural resources will be built into the analysis in an environmental assessment or environmental impact statement. So really think of them as parallel tracks, but working together. How do agencies comply with it? Well, there's a 4-step process, and I have a really good chart on the next slide for those of you who are more visual learners like me. But those are the 4 steps. There's a consultation process. You see if there's any affected properties. You address the impacts to those properties related to your action, and you try to achieve some sort of accommodation, resolution to that process. And I told you, here's the chart. Here it is. And I think it's really nice because it shows you that if the answer is no to some key questions at any point in the process is over. So if you start and you determine that there's no potential to cause effects to historic resources or properties, you're done. You have to get concurrence on that. You have to get notification to the state historic preservation officer, a tribal historic preservation officer. But the process could be done. If there's a possibility that there are historic properties in the area, so there could be, you do some initial analysis, and if those properties are not affected, in other words, they're in the area but not close enough, or your project's not going to have any visual effects to that property that interfere with the cultural significance of the property or something like that, then the process stops. That's the second line down. The third line is you assess, okay, they are there. There are some properties. There could be some effects. Are they going to be adverse effects? And if the answer is no, the process stops there. Only if you're doing a project where you know there are historic and cultural resources, there's a possibility of effects, you determine there to be adverse effects, you start working to resolve those effects. The last step on the bottom of this chart. And ordinarily that's done through what's called a memorandum of agreement, an MOA, or a programmatic agreement. Basically, it's a signed document with provisions, suggestions, ideas on how to preserve, conserve some of the historic features of the properties that could be adversely affected. I'm working on a project right now in North Dakota. It's replacement of a rail bridge. The rail bridge is 150 years old. The parties have stipulated that when that old bridge is demolished, they're going to take pieces of that bridge, restore it, and put it into a local museum so that there's some remembrance, some proof of the engineering of this old historic bridge. That is a perfect example of a resolution of a 106 process. Obviously, there's a historic property affected by the project, the bridge. Obviously, it's going to be adversely affected. They're tearing it down because they have to. It's unsafe. So you come up with a resolution through a memorandum of agreement. In this case, is preservation of the resource by taking some pieces of the bridge, putting it back together and storing it in a local museum. That's a really good example of how the Section 106 process works.
Fred, 2 questions. Go back to that for a second. So one is at the beginning and the other is at the end. At the beginning, if I have a large infrastructure plan and let's say a broadband build out, it makes sense. It's probably dumb not to run the traps on historic places that might be impacted by my project. It is penny wise, pound foolish not to at least do some analysis as to what am I going to run into as I do this build out.
Correct.
And there's ways to, and there's methods to find out, I mean, other than just going to look at the National Historic Registry, and I assume there's consultants that will give you reassurance or give you insight as to what impacts you're going to have and whether you're likely to run into a problem.
Precisely, and some of those consultants are my best friends.
Yes. So the other one is at the end, and these are the stories you see in the news, like with the pipeline. It seems like in some situations there's no resolution, that there's nothing that is going to solve the problem on the other side, the people that are opposing you. There's nothing that's going to satisfy them.
Right.
So failure that happens because that's rare, right? I assume, and like with NEPA, it's most common that you get this approved, but it does happen sometimes that you totally have to redesign or completely work around your whole project because there is.
Well, I will say yes and no. Let me give you an example. I worked on the rebuilding of the hospitals in New Orleans after Hurricane Katrina. And some of you remember the historic hospital was devastated. The Veterans Hospital was devastated after the hurricane. A lot of properties in and around the area that were also damaged were historic. Some of the old bullet homes, the bullet houses, in New Orleans. And we had a proposal to rebuild the hospitals, and that was going to require demolition of those homes. They were already damaged, but it was going to require demolition. The local historic group completely opposed to us using that site for the hospital. We built into the MOA a plan to pick up and move those homes and preserve them in place elsewhere. They did not like that plan. Under the Historic Preservation Act and under the regulations, Craig, if they disagree, they do not have to sign the MOA, but the project proponent of the agency can still move forward. In other words, it is the effort to establish measures to address the adverse effects on historic properties that matters, not that everybody agrees to them, right? If you go through the process and you do something that the state historic preservation officer agrees to, that the advisory council on historic preservation, we're going to get to that in a second, that they approve, you're done. And if the 1,000 friends of the bullet homes in New Orleans is still opposed to it, their only remedy is to run to court. They can't stop you from doing the project under the Historic Preservation Act, which raises the ACHP. I remember the CEQ was the agency that runs NEPA. The ACHP is the agency that runs the Historic Preservation Act. Again, its own federal agency. They write the NHPA regulations, and they can sometimes play a role in the review of a controversial project. And in the example I just gave you, Craig, they did, because everyone knew it was going to be highly controversial. The rebuild of the facilities after Katrina in New Orleans, very controversial. So the ACHP was at the table the whole way. So they were aware of what we were trying to do. They were aware of the sensitivities, but they're not always involved in consultations. It's only when it gets kind of elevated to that level. Either there's disputes or there's controversies or that type of thing. They're there as the arbiters to try to resolve these issues as best they can. And you know what? For the most part, in my experience, they do just that. They're not there to stop things. They certainly have a preservation bent to them. That's that's part of their name. Historic preservation, that's part of their name. But they also understand that their role is to facilitate approval of these projects and make sure these processes are done properly. So I just want everybody to be aware of the role of the ACHP when you see their name. Importantly, and then this just really one or two last slides, in the world of the FCC for tower siting, not so much for broadband yet, for tower siting, there are what's called institutional programmatic agreements for tower projects. This was negotiated between the FCC, the ACHP, what I just told you about, as well as the National Organization of State Historic Preservation Officers. And what it did is created a set of standards and procedures so that towers could be built quickly and expeditiously. It included a whole list of exclusions. If you're doing ABCD, you don't even have to apply to the historic preservation law. And if you do have to apply, these are the exact steps you have to follow. It was originally executed in 2005. It's been updated, but it's a great vehicle by which these projects can be expedited. I caution people, there are many differences in dealing with tribal governments. So you can deal with your state historic preservation officer. When you're dealing with the tribal historic preservation officer, the rules are sometimes different from tribe to tribe. Not enough time to go into it, but I wanted to make sure to point that out to you. So I'm.
And oh, by the way, here at Venable, we have a tribal practice that could help in that.
That's right. That's right. But I raised the programmatic agreement in this case because I think it's a crucial thing for this industry's considerations. As you are trying to do more broadband build out for those types of projects, I would strongly urge the industry's participation with the FCC and the federal government to see if there is an additional programmatic agreement that can be created and applied for those types of projects as well. It is a tremendously productive and helpful vehicle to streamline and expedite approvals of these types of projects. It's worked very well, I would argue, for the tower and the tower siting context. And I think it could work very well for the broadband and fiber laying context as well.
Just to clarify, so what you're saying is that what is needed is a broadband system, just like there is for towers, where there is certainty for industry so that we know that it's not going to hit a roadblock.
Exactly, because like towers, Craig, let's face it, the nature and the scope of these projects is similar, right? I mean, they're not going to be drastically different. So if we can get the level set expectations of what processes we're going to use, and even better, what types of projects shouldn't even have to deal with this process because they're relatively minimal, this type of agreement could be very useful, I think, moving forward. A couple of last points, because I know we're getting close on time. Overlap to NEPA. You anticipated a couple of these points, Craig, in your questions to me. Get ahead of the process. Start as soon as possible. You said that before I said it. Know your rights. It does not mandate preservation. It doesn't require unanimous consent. You do not have to get bogged down by parties that are going to be obstreperous and trying to gum up the works. You don't have to be bogged down by them. And don't hesitate to use tons of excellent publicly available resources that are out there. There are tons of memorandums of agreement, tons of programmatic agreements out there to use as models for your compliance with Section 106. You do not have to be reinventing the wheel in order to get through this process. Well, 58 minutes on two of the most important natural resources statutes that affect infrastructure law in the United States of America. I know it was quick. But I also don't want to let the hour go by. If there are any further questions, and certainly on this screen, let anybody in the audience feel free to contact us directly if you have any follow-up or questions for us. And Chip, like I said, I'm going to be following the revisions to the CEQ regulations. I'm going to be following how the FCC and some of the other agencies are going to try to promote the agency's agenda to build out the broadband network in the U.S. and glad to keep you and your members informed as those things happen.
Well, Fred, Craig, thank you. This is a very timely conversation, very helpful and very valuable information overview. As everyone who's listening and watching this webinar, this is a wealth of experience and expertise that is learned through the hard challenges of going through all of these different federal actions to get the permits to make major projects, infrastructure and broadband projects successful. So we thank you very much for this very valuable time that you've given us, and insight and information. And we wish everybody who's been able to watch and participate that this is something that is valuable to them as well. So thank you both, Fred, Craig.
Our pleasure.